standing to sue over the alleged usurpation of the General Assembly's rights under the Elections and Electors Clauses. That is absolutely true here. The Wood Court, the 11th Circuit Wood opinion, says the same, citing Walker, because federal courts are not constituted as freewheeling enforcers of the Constitution and laws. And that is the injury that underlies all of their claims, which is why they lack standing. I'm not going to get into traceability as much because I think the most useful aspect of the traceability is the crystallizing of plaintiff's complaints, and as I've indicated, the isolating of the state acts in particular. On sovereign immunity, I only want to highlight that a decision just came out in Michigan seeking very similar relief. We'll get you the site. It is Michigan, it's against Whitmer, King versus Whitmer in the Eastern District of Michigan. Walks through all of the issues in this case and rejects the claims, denies the relief. On sovereign immunity, they raise the point that under Young, you can only get prospective injunctive relief. That's not decertification. That is a retrospective, and so sovereign immunity would bar that. And they do seek to prevent the governor from mailing the results. That can be prospective, but there's just not relief for it. So that's all I'll say on sovereign immunity. On latches, the Michigan Court also joined in with Judge Grimberg on latches in the Wood case and said that there is time that is inexcusable. The court is well aware of the elements. Was there a delay? Was it not excusable? And did the delay cause undue prejudice? Judge Grimberg has already looked at this argument in the context of the Wood case and the challenge to the consent order and said latches applies. And it does here for all of the plaintiffs' arguments. And all you need to do, again, is go back to that page 20 and see why. They say that their policies, the state's policies, led to a de facto abolition of the signature requirement. The complaint at paragraph 58 acknowledges in Exhibit 8 that happened in March of this year. There's been plenty of time that they thought that the secretary overstepped his bounds to bring a challenge in that case, or to bring a challenge even afterwards, challenge the OEB. They did not. They say on page 20 that the state, picked the Dominion system. They tell you on paragraph 12, that happened in 2019. There's been significant litigation over the Dominion system. Nothing has been held in order. The Dominion system is unconstitutional, is flawed, or anything else that has stuck. Third, they say that their regulation, the absentee ballot regulation, permitted absentee ballots is unlawful and unconstitutional. They tell you in paragraph 60 that happened in April of 2020. Georgia law and the Administrative Procedures Act specifically allows you to challenge rules 50, 13, 10. That wasn't done. They certainly could have. And you don't need the fraud, as they allege, to happen first, because their argument is not based on the fraud. It's based on the usurpation of power by the executive branch. That can be challenged when the rule has been promulgated, when the order is out, and when the Dominion machines were selected. We raised in our brief several forms of abstention, and truly, Your Honor, they kind of all get to the same place under different theories. And again, the reply brief made this point to clear us. I think at the end of the day, while we'll rely on our briefs in terms of why those matter, and the Michigan court found that Colorado River abstention should apply, there are parallel proceedings in state court and argue why it shouldn't. They argue that in voting rights cases, the 11th Circuit does not typically abstain. And those cases are slightly different. They're challenging an underlying statute for the most part. Siegel is a different case. But they're mostly challenging underlying statutes. And there's not a pending election challenge on the same thing in state court. It's like the other cases we've seen that we've defended since the gubernatorial election in 2018. And so, no, I don't think so. But I think the Bush v. Gore analysis is the one that is most critical. And it is that simply the legislative scheme for electing presidential electors is set forth in the code in Title 21. It has a means of challenging fraudulent, illegal votes. It has a means of allowing the secretary to address various issues, the state election board to pass regulations. All of that authority has been delegated by first Congress to the Georgia legislature and then to the executive branch. That is the scheme that is put in place. And that is exactly what they seek to turn on its head. And what Justice concurrence on which they rely says makes that impossible. Because the Supreme Court said at page 120 for the court, in that case the Florida court, to step away from this established practice prescribed by the Secretary. The state official charged by the legislature with the responsibility to obtain and maintain uniformity in the application, operation, and interpretation of election laws was to depart from the legislative scheme. Read the proposed order. That's exactly what the plaintiffs seek here, and that's exactly what their own authority says the court cannot issue in terms of relief. And that would actually trump the remaining claims because it would violate the elections clause in order to arguably save some other vague right in terms of due process. Turning to that, let me talk briefly about the absentee ballot regulation, the opening of the ballots. There is nothing that is inconsistent with that, number one, because if you look in the election code, there are 5 times that the General Assembly said something cannot occur earlier than X date. This doesn't say that. This says beginning on this date, they can do this, but it doesn't say it can only happen then. And the 5 times elsewhere in the code would suggest that the legislature knew how to change it if they wanted. That's 21-2, 132, 133, 153, 187, and 384. They're simply reading the regulation to create a conflict when every piece of federal and state law says that you read it to avoid the conflict. In terms of the settlement agreement itself, I think Judge Grimberg has sufficiently answered and analyzed that, and it fills a gap. There's no conflict. They can't point to any language that does. And at the end of the day, it's an OEB, an official election bulletin, not a statute and not a regulation of the state election board anyway. On the Dominion machines, I think we'll rely on Mr. Miller's going to talk about that a good deal. But also, they argue that the audit somehow doesn't save it because of curling, and that we're stopped from raising curling. There's 2 problems with that. One, estoppel doesn't apply. There's been no final order, so we're not stopped from doing anything. That's the Community State Bank, which is a strong decision from the 11th Circuit, applying Georgia law in 2011. And 2, there's not been an order in curling saying that the machines are unconstitutional. There have been 9 preliminary injunctions filed, no standard relief, and it ignores, the entire premise of the argument ignores that when a voter gets the ballot from the machine, they can read who they voted for. And when the hand count took place, they didn't scan it back in. They looked at what the ballot said and who they voted for, and that's why things were put in different boxes. And their own affidavits talk about that provision of separating the boxes by hand. It resolves the issue. The remaining theories fail. Again, I want to be cognizant of time and save some time for rebuttal. We'll rely on our briefs in terms of the merits of those, but the equal protection and due process allegations I think are addressed in Wood from the 11th Circuit. On procedural due process, to the extent that that is the due process claim, they don't challenge the Georgia election means of correcting as somehow invalid or insufficient. In fact, they raise it and say you can't have a procedural due process claim if you have a remedy. You can't have a substantive due process claim if it doesn't shock the country, which having to use the remedy here, they can do. Your Honor, with that, unless there's questions, I'll reserve the rest of my time.